Okay, we're back. We just ran out of time here. We only got 10 minutes to do this in. Okay, so this is the second part, and we're going to try to continue on. And without me interrupting, Vicky, I'm going to let you go ahead and read this paragraph here again on count one charge, Vicky, and then I'm going to put my little insight in on that.
Okay, that on or about the 23rd day of October 71 in Jefferson County, Kentucky, the above named defendant, Stephen Ray Thomason, willfully cut Eugene Kaufman Sr., not intending to cause his death, and not in self-defense, nor in the lawful arrest of a person charged with a crime or in doing any other legal act, so that Eugene Kaufman Sr. died from the injury within 6 months.
Okay, now just kind of focus on this other one here, Vicky, but don't say nothing. I got a few things I want to comment on this first one, this first charge. Now, I don't know how they came up with all this definition here, not in self-defense and not intending to kill him and all this. Where did they come up with this? And that he died within 6 months? He died that night. He died within a matter of half an hour there. I sat there and watched him die. Now, they came up with all this on count one. Look, where did they come up? What tree did they pick these apples out of and came up with this decision? I don't know. Because if you go to count one, or count two here, what does this say, Vicky?
That on or about the 23rd day of October 71 in Jefferson County, Kentucky, both the named defendants maliciously cut and wounded Eugene Kaufman Jr., intending to kill him.
Intending to kill him. If they was out there and trying to kill somebody, how did they come up with this determination on this guy?
Right.
On my dad.
Right.
You see what I'm saying?
Right.
They was already out here trying to kill my brother.
Right.
Now, how did the court sit in the courtroom or sit wherever they sat around a desk or whatever and come up with an idea that it was not in not in self-defense, it was not intended to kill him when he was already out here trying to kill somebody before this man even walked out the door. He was out here already trying to kill him.
Eugene
He was
Jr.
trying to intend to kill him. They determined that. Now, you might want to go on with that, Vicky. It fires me up. I want people to know I'm fired up about this. And it is stamped.
Right.
I ain't got it stamped by and this is a true bill. I want to make sure that's a true bill. This is a true document, court document that I have found down there after 28 years that was been hidden from me.
Right.
Again, I would like to point out witnesses. This is on the indictment. And I would like to point out for sure these witnesses. Again, I want to point out these witnesses. Ricky Allen Webb, he turned state evidence. David Miles, remember? We read the papers a while ago where they said Dave was guilty for murder. He also killed, but they turned state evidence, but you don't see their names up here. You don't see their names. You don't see Webb's name up here with them. You don't see David up here on the 1 to 6. It just got him down here for this. I don't know how he didn't get an indictment from my dad's. But anyway, go focus back down here on this witness. Look at all the witnesses. All these witnesses. We got all kind of evidence. We got overwhelming evidence. We got pictures of the blood scene. We got
Show them how they stabbed you.
we got just blood everywhere, just blood. Where I mean, there was a lot of blood. Here's a blood scene here. Two big puddles. I mean, there was a lot of blood, a lot of nasty stuff. Power tools where they used against us, and the rifle out here where Dad tried to hit the guy over the head trying to defend his son. I mean, it's just. But anyway, we're going to move on to some more evidence. I don't want to clutter you up here. I think the most important evidence is the court documents. It's self-explanatory. So here we are.
You have 5 minutes.
He didn't want to go. He didn't want to go in front of a jury. So instead of going in front of a jury, They decided to go in a little back room and make a flea bargain. This is their flea bargain.
Okay, which states, for the Commonwealth, for the defendant Thomason, Mr. Edward L. Clark, his attorney was Mr. Frank Haddad. For the defendant Miles, Mr. John Fowler, heard before Honorable Judge H. Koonsman, Judge, on October 18th, 1972. Mr. Clark, the recommendation for Miles is that
Now,
it be amended.
Mr. Clark is for Commonwealth.
You're right.
Okay, that's the that's the prosecution that's supposed to be representing the victim's family.
Which is the Kaufmans.
Which is us, is the Kaufmans.
Right. Mr.
Okay,
Clark, the
right,
recommendation for Miles is
And
that
what
it
I'm
be
gonna do,
amended.
Vicki, I'm gonna let you read a paragraph, and I'm gonna give these people an idea what I think about a paragraph.
Okay.
Okay.
It states, Mr. Clark, the recommendation for Miles is that it be amended to assault and battery, and that the recommendation is 6 months as to Thompson on count 1. The recommendation on a plea of guilty is 3 years, and count 2 filed away with leave. Okay.
Okay, now this is my thought about that. It says the recommendation for Miles is that it be amended to assault and battery, and the recommendation is 6 months.
Right.
Is to Thompson for 6 months. Which one are we talking about? Are we talking about count 1 or count 2? It must be, they must be talking about count 2. Even though Eugene ain't there for court,
Right.
you know, or nothing like that, or he can't be there because he's in a mental hospital, they still gonna give this guy 6 months, Miles. Even though Eugene's in a mental hospital, got 400 stitches in him, almost died.
Right. They went on and did it.
Right, they
without
went on and
Eugene?
even did it without Eugene Jr. being there.
Man.
As far as count 1, the recommendation pleaded guilty is 3 years. You only get 3 years for killing a
And that's-
father,
yes.
killing a father that came out there protecting his son that he was trying to kill. Now I don't understand that.
Right.
And on count 2, that's my brother. Count 2 was my brother, Eugene. They filed that away with leave to reinstate.
Right.
Okay, now, I don't understand that. All the witnesses, this is a Commonwealth state, but they filed his away to reinstate.
Right.
Now, I don't understand, I don't understand that. Why didn't they come back and get all these witnesses and go ahead and take count 2 on? They didn't want to take count
Right.
2 to court. They just want to file away and forget about it. And that's what happened. But meanwhile, go ahead and just read his little plea on Dad here and let them see that.
The court, Mr. Haddad, to acknowledge the identity of the defendant, Stephen Ray Thomason. The court, Mr. Haddad, yes, sir. The court, have you explained Mr. Thompson's rights to him? Mr. Haddad states, yes, sir, thoroughly. The court, how does he wish to plead at this time? Mr. Haddad states, he wishes at this time to withdraw his plea of not guilty. Herefore entered, and your stamps over top of that.
I can't
And
see it.
entered the plea of guilty to
Yeah.
the first count in his indictment.
Yeah, that's Dad's account.
Right, right.
He's
And that,
pleading guilty to Dad's.
right,
The 1 to 6 years.
right.
Okay. Now move on to the next page.
Yep. 1 minute, Dad.
All right, well, just keep going and we'll start another movie here,
Okay, and this states, the court, Mr. Thompson, have you heard your attorney, Mr. Haddad, state that you wish to enter a plea to guilty? Is that your desire at this time, Mr. Thompson? Yes, sir. The court, do you understand that the plea to guilty, that there will be no trial by jury? Yes, sir. The court will merely pass the judgment and will be the end of it. Mr. Thompson, yes, sir. Do you understand that there will be no appeal? Yes, sir. Are you at this time under the influence of alcohol or narcotics? No, sir. Have you been treated by any mental disease? No, sir. Have you ever been in mental hospital? No, sir. Have any promises been made to you by the plea guilty and the court will go easy on you? No, sir. Do you understand that no one could make such a promise that would bind me